Raise your right hands. Do you solemnly swear and or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. And so what's going to happen next, ladies, I'm going to give you, Ms. Chen, the opportunity to speak first. You know, it's up to you to provide proof to me that the defendant, Ms. Brown, did default in the terms of her lease by not paying rent. It's also up to you to provide proof to me that you comply with all the laws of this state as they pertain to evictions. Now, while Ms. Chen is speaking, I'm going to ask that you, Ms. Brown, refrain from interrupting her. I need to make sure I hear everything that Ms. Chen is stating. Okay, Ms. Brown?
Yes, sir.
Afterwards, once Ms. Chen is through, I'm going to give you, Ms. Brown, the opportunity to defend.
All right, guys. Today we're stepping into a courtroom where everything starts calm but serious. The oath is taken, the rules are laid down, and the judge makes one thing clear. This case will come down to proof, not emotion. The landlord must show missed rent and legal compliance, and the tenant will later get her chance to respond. No interruptions, no shortcuts. Right from the opening seconds, you can feel the balance of power, the formality of the process, and the quiet tension that always hangs in eviction court, where lives can shift in a matter of minutes.
Yourself. It's going to be up to you to provide proof to me that you should not be evicted for whatever legal reasons you can deem so, approve so. And while you're speaking, Ms. Brown, I'm going to ask that you, Ms. Chen, refrain from interrupting her so I can hear everything that Ms. Brown is stating. Okay, Ms. Chen?
Yes, sir.
All right. With that being said, are there any questions before we proceed on with today's case?
No, sir.
Okay, Ms. Chen, you may proceed with your case, ma'am.
Yes, sir. So I have a lease agreement dated July 22nd for a monthly housing installment rate of $659. There is a concession of $220 per month, making the rent owed $439 per month. We do need to amend our petition to ask for November and December's rent, please. But outside of that, we do have an electronic signature on this document going until the end of July 2026, or July 21st, 2026. This was signed by us. The last payment we received for this housing installment was October 3rd. And so we have failed to receive any payments in November and December. And that is why we filed for eviction. We served a 3-day notice to vacate. It was hand delivered on the 8th of December.
Okay. I'm looking through some of the documents you provided to me. I see that you provided me with a copy of the notice to vacate. Looks like Mr. Whittington was the person who actually delivered this. Is that correct?
Yes, sir.
Okay. And I also have, looks like it's a summary. It's a ledger, which details all of the transactions. And this is up until December 7th. And as stated in your testimony, the last time you all received a payment, you said October 3rd, but it does say from October 3rd right here, $195. I see that. The next document I have in front of me is a lease between you and the tenant. It does indicate that it was executed on or around July 22nd of 2025. Everything was done electronically. And it does detail the terms of the lease, as you stated on the oath. All right. And anything else before I move on to the defendant?
No, sir. Just that we have not received payment as of right now, and we are seeking eviction.
Okay. All right, Ms. Brown, here's your opportunity to defend yourself. Tell me why you feel like you should not be evicted from this unit.
I don't have a problem with being evicted. I'm currently packing and moving out. It is taking a lot longer than I expected because I don't have a vehicle to move stuff and I don't have anyone helping me. The reason I didn't pay the rent I didn't get my full Social Security check. I'm on disability, so I only get one check once a month.
All right, guys, now the landlord lays out the case piece by piece. Dates, dollar amounts, electronic signatures, and payment history are all placed on the record. The judge carefully checks the ledger, confirms the lease terms, and verifies that the notice to vacate was properly delivered. This part isn't dramatic on the surface, but it's decisive. Paperwork speaks louder than feelings here. Every document tightens the case, and with each confirmation, the outcome starts leaning in one clear direction.
And I informed them that I didn't get the full payment, and they said that I had to pay the whole thing before it got the eviction notice, and I don't have that amount of money. And I've tried to ask people to help me, but I don't have that much family. And so I'm moving out. I'm not trying to stay here any longer than necessary. I just have a hard time packing because I don't have any transportation. The car that I received from my mother when she passed away, the tags are out, and I don't have a driver's license. So,
Ms. Brown, have you been here before?
yes, sir. I was here a couple of weeks ago, maybe like 2 weeks ago, but the situation hasn't changed for me. I don't really have help. My fiance works every day except for weekends.
Correct me if I'm wrong. Miss Chen, what happened with that case about 2 weeks ago?
I think it's because they didn't give me the eviction notice the right way, so we
Proper
had to.
notice to vacate? Okay.
Yes, sir.
Okay. So this time around, they did give you proper notice.
Yes,
Okay.
sir.
All
He
right.
did hand it to me.
Okay. That was the problem last time. So I didn't mean to stop you, but
Oh no, it's okay.
Groundhog Day. I heard this your response from the last time, and it again. I heard it. So there's no really defense. It's just that you're just having a hard time getting everything moved out. I heard
Yes,
you telling me about your fiance and about your financial situation. I was just wondering. I said, I know I heard this case, before, but now I remember what happened in
Yes, sir.
Okay, all
But
right.
that's the only thing. Like I'm trying to get out as soon as possible. I don't have any funds to pay the rent. I didn't get my full check this month. All the money is going towards working on the RV that we have. But other than that, I'm trying to get out as soon as possible.
Okay.
All right, guys, this is where the human side takes over. The tenant doesn't deny the rent or fight the eviction. Instead, she explains disability income, a reduced check, no transportation, and no real support system. She's not resisting the move, just struggling to complete it. When the judge realizes he's heard this case before, the tension sharpens. Sympathy is present, but the law doesn't bend easily. You can feel the weight of repetition here, like a problem that never quite finds an exit.
Okay. Based upon everything that I've heard today, I'm going to rule for the plaintiff for possession of the property in question, 2826 South University Park Drive, apartment 928, C as in Charlie, Waco, Texas, 76706, as well as back rent in amount of $878. That's $439 for November, $439 for December, plus court costs, which is an additional $144. You, Ms. Brown, have the right to appeal. Your appeal bond is set at $878, and you have 6 days from today's date to appeal. In the event that you do not appeal on or before that 6th day, and if you are still occupying the premises, then at that time, you, Ms. Chen, may, on behalf of the Grove at Waco, file a writ of possession. A writ of possession is...
All right, guys, this is the turning point. The judge issues the ruling clearly and without hesitation. Possession goes to the landlord, back rent is calculated, court costs added, and appeal rights explained. Then comes the warning that hits hardest. The writ of possession. No notice of the exact time, no courtesy call. Just constables, a deadline, and removal if needed. This moment strips away all uncertainty. The case is no longer about what might happen. It's about what will.
Where the constable will serve you with a final notice, giving you 24 hours to move out. If you do not comply with that 24-hour notice, then at that time they will be back over there within a time frame, with an agreed upon date and time with Ms. Chen. I want to make sure that I'm clear. After you are served with the 24-hour notice to vacate, Ms. Chen and the constable's office will have an agreed upon date and time to meet back over there. They will not notify you of that date and time. It's something that they would agree upon. It could be 6 in the morning, could be 7 in the morning, it could be noon. Don't know the actual date. That is the only people privileged to that information would be Ms. Chen and the constable's office. And so you may get a surprise and the constable is going to be there and they're going to make you come out. And then at that time, the maintenance personnel will be able to safely and peacefully remove all of your personal belongings from inside of the unit and place them outside of the unit. And so I just want to make sure you're clear, that I'm clear on this. You do have the right to appeal. But if you do not appeal and you do not honor the notice given to you after the writ of possession has been filed, then the constable will be back over there to execute it. Do you understand, Ms. Brown?
Yes, sir. So I have 6 days to get everything out.
You have 6 days to appeal, and if you're still staying there after the appeals date has expired, the constable will give you a 24-hour notice to move out.
And is the appeal for paying the back rent or is just to...
The appeal is disagreeing with my judgment today. That's
Okay.
what the appeal is. Okay. Any questions?
I do have a concern because they told me that my rent that I would owe was close to $2,000. If I had known it was only $800, I would have found a different way to pay it. But they told me...
Let me explain. I do not award late fees. I do not award utilities.
Mm-hmm.
And any other fees that may be charged upon you. That's something that I do not honor in a judgment. The only thing that I can honor is the back rent and court costs. So whatever amount that they are telling you you actually owe them, that is purely between you and them. However, the judgment legally can only be for back rent and court costs and maybe attorney's fees. Okay?
Okay. If I would have known that, I would have had the 800. I had the 800.
Brown, you're not understanding. Okay, let me see if so here's what I'm trying to tell you. In court, the judgment is only for back rent and court costs and maybe legal fees. But the amount you actually owe them is totally different.
Okay.
Okay, so what you actually owe them is more than the judgment amount.
Okay.
All right. So even if you would have taken $878 to them, you would have still been evicted because it's not what you actually owe them. I can only grant them judgment for back rent and court costs, not for late fees, not for utilities or any other fees that you had agreed upon in your lease.
Okay.
All right. Okay. All right. That being said, judgment favor for the plaintiff.
All right, guys, the final moments bring a painful realization. The tenant learns the court judgment is far less than what she was told she owed. The judge explains the difference between legal judgment and actual lease debt, making it clear that even paying the court amount wouldn't have stopped the eviction. It's a harsh lesson delivered too late, and you can hear the regret settle in. This is how eviction court often ends. Clarity arriving after consequences are locked in. If this breakdown helped you understand the process, make sure to like the video, subscribe to the channel, and we'll see you in the next video.